Imagine this. A listed company has experienced directors, independent directors, strong financial performance, excellent corporate governance ratings. Yet, it becomes non-compliant under SEBI regulations. Why? Because its board has only 5 directors, or because it failed to obtain a special resolution for a director above 75 years, or because it issued superior rights shares but did not increase the number of independent directors. Sounds surprising? These are some of the most overlooked provisions under Regulation 17. And in today's video, I will show you a simple compliance checklist that can help you identify these violations in less than 1 minute. Stay till the end because I will also discuss the secretarial audit observations that frequently arise under these provisions. Welcome to Corporate and Securities Law Compass, the channel dedicated to practical learning of Companies Act 2013, SEBI regulations, FEMA, corporate governance, secretarial practice, IPO and SMEIPO compliance, NCLT and securities law developments. If you are a company secretary, compliance officer, director, CA, CMA, lawyer, investor, or law student, this channel is for you. Let's begin. Quick question. Can a listed company with one woman director, adequate independent directors, fully compliant committees still violate Regulation 17? The answer is yes. Let's see why. Statutory requirement. Regulation 17(1)(c) provides that the top 2000 listed entities must have not less than 6 directors on the board. Not 5, not 4, at least 6 directors. Why did SEBI introduce this requirement? Think about large listed entities. They have thousands of shareholders, complex operations, significant regulatory obligations, greater governance risks. SEBI believes that a small board may not have sufficient diversity of skills and expertise. Therefore, larger listed entities must maintain a minimum board strength of 6 directors. Practical example. ABC Limited is among the top 2000 listed entities. Board composition: MD equals 1, WTD equals 1, independent directors equals 2, non-executive directors equals 1, woman director equals 1, total directors equals 6. Result: fully compliant. Compliance test. Now consider this. Everything remains the same, but one director resigns. Board strength becomes 5. Question: is the company still compliant? Answer: no, because Regulation 17(1)(c) requires a minimum of 6 directors. This is one of the easiest compliance checks during secretarial audit. Regulation 17(1)(d). The control versus governance problem. Now let's discuss a fascinating governance concept. What happens when promoters hold voting rights far greater than ordinary shareholders? How does SEBI protect minority investors? The answer lies in SR shares. What are senior equity shares? SR means superior rights equity shares. These shares carry higher voting rights. For example, 1 ordinary share equals 1 vote. 1 SR share may carry 10 votes, 20 votes, or even more voting power. This gives promoters stronger control over the company. SEBI's concern. If promoters enjoy superior voting rights, who protects minority shareholders? Who ensures objective governance? Who challenges management? SEBI's answer. Increase board independence. Regulation 17(1)(d), where SR equity shares are outstanding, at least 50% of the board must comprise independent directors. Remember, 50% independent directors, not 1/3, not 2 directors, half of the board. Practical example. Board strength equals 8. Independent shares equals 3. Company has SR shares. Required independent shares, 50% of 8 equals 4. Actual equals 3. Result: non-compliant. Memory formula. SR shares present. Immediately think 50% independent directors. That's the shortcut. Regulation 17(1)(a). Can a 78-year-old independent director continue on the board? Many people answer no, but that answer is wrong. Let's understand why. Statutory requirement. SEBI does not prohibit directors above 75 years of age. However, if a non-executive director has attained 75 years, the company must obtain shareholder approval through a special resolution. Why did SEBI introduce this rule? SEBI believes shareholders should know why the director is being retained, what expertise the director brings, whether continued service is beneficial to the company. Therefore, shareholder approval becomes mandatory. Important exam point: ordinary resolution, not sufficient. Special resolution, mandatory. Remember this distinction. Examiners love asking this question. Practical example. Mr. Sharma, age equals 78 years. Position equals independent director. Company passes ordinary resolution. Compliant or non-compliant? Answer: non-compliant. Special resolution was required. What must the explanatory statement contain? The notice must justify experience, industry knowledge, board contribution, strategic value, reasons for continuation. This justification becomes part of shareholder decision making. Important proviso. The company need not wait until the director turns 75. Approval can be obtained at appointment, at reappointment, any time before attaining 75 years. This allows companies to plan compliance proactively. Secretarial audit checkpoint. Whenever you review a listed company, ask these three questions. 1. Is the company among the top 2000 listed entities? If yes, board strength must be at least 6. 2. Does the company have SR equity shares? If yes, 50% independent directors required. 3. Is any non-executive director above 75 years? If yes, verify special resolution and justification. Top 2000 listed entity, minimum 6 directors. SR shares, minimum 50% independent directors. Non-executive director above 75, special resolution required. Remember these three rules and you will solve most Regulation 17 questions instantly. Today we learned minimum board strength requirement, applicability to top 2000 listed entities, SR equity shares concept, 50% independent director requirement, directors above 75 years, special resolution requirement, secretarial audit checkpoints, practical compliance formula. Before you leave, answer this question in the comments. Which Regulation 17 provision do you think companies violate most often? A. Minimum board strength. B. Independent director requirements. C. Directors above 75 years. D. Board composition. In the next episode of this Regulation 17 Masterclass series, we will discuss Regulation 17 1C, shareholder approval of directors, reappointment rules, additional directors, compliance timelines, secretarial audit red flags. Subscribe now and join Corporate and Securities Law Compass as we simplify corporate and securities laws with practical insights and real-world examples. Thank you for watching. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.